This is our review of Realty School 101's California Real Estate Principles course, designed to prepare you for the California Broker or Salesperson exam. We'll give you a quick overview of the real estate industry and with 24/7 support by calling number 888-385-0087. You can request help as you need it. When we go through this presentation, I will point out which information is more important for you to know for exam preparation. Let's start the review to ensure you're fully prepared for the principals exam. The State Real Estate Department Act, which defined real estate brokers and salespersons, provided for regulation and licensing, and created a state real estate department and the Office of Real Estate Commissioner, which was approved by Governor Stevens on May 27, 1919, and went into effect on July 27, 1919. The act was upheld against legal challenges as a valid exercise of police power. California became the first state in the U.S. to have a standalone specialized real estate department and the first valid Office of Real Estate Commissioner. Ray L. Riley was appointed as the commissioner in 1919, and the department issued 10,700 broker licenses and 13,500 salesperson licenses from 1919 to 1921. California passed its first real estate license law in 1917, signed by Governor William D. Stevens. The 1917 law was declared unconstitutional by the California Supreme Court in 1918. A revised act, the State Real Estate Department Act, was approved in 1919 and went into effect in July of that year. California created the first standalone specialized real estate department in the U.S. with the first valid Office of Real Estate Commissioner. Ray L. Riley was appointed as Real Estate Commissioner in 1919. Edwin T. Kaiser was appointed as Real Estate Commissioner in 1921 and was responsible for the First Amendment of the 1919 real estate law. The purpose of the department was to make it difficult for crooked real estate brokers to remain in business and to prevent offenses by educating both brokers and the public. Which year upheld the California Real Estate License Law? The correct answer is 1919. The California Real Estate Commissioner is appointed by the Governor of California. Doug McCauley is the current California Real Estate Commissioner, and he helped us adapt to computer-based license exams. Thanks to Doug McCauley, California converted its supplemental exam to computer-based format, which increased access to licensure. The Real Estate Commissioner's regulations have which of the following? A, authority only over the California Department of Real Estate staff. B, same force and effect as law. Or C, no impact on licensees. The correct answer is B, same force and effect as law. Again, the question asked, the Real Estate Commissioner's regulations have which of the following? Authority, same force and effect as law, or no impact? Authority only over the California Department of Real Estate staff. That is not the correct answer. Same force and effect as law is the correct answer, and no impact on licensees is not a correct answer. Every 4 years, the California Department of Real Estate requires all licensees to complete a state-approved CE course and submit renewal forms. It's also a great time to notify if there are any changes to your name or your address. Remember that it's every 4 years. And that license term is the same for both sales and brokers. The salesperson license education requirements are as follows. You'll need to take a principles 45 credit hour course, practice 45 credit hour course, and your choice of an elective that's also approved by the California Department of Real Estate, and that's 45 credit hours as well, with the total being 135 credit hours. As far as broker license education requirements, you need 8 college level courses. 8 college level courses for broker license education requirements. The real estate license law requires that a fictitious business name must appear on your broker or corporation officer license before the name may be used in conducting activities for which a real estate license is required. A fictitious business name, if used, must be filed with the county clerk. You may also wish to file an abandonment of the DBA with the county clerk, and the statement must be renewed every 5 years. Prepaid rental listing service license. This is a business that provides lists of available rental properties to prospective tenants for a fee. The license required to operate this business is called a PRLS license. Before getting a PRLS license, applicants must get their contract approved by the DRE, the Department of Real Estate. The contract is between the licensee and the prospective tenant. You may be asked, how long is a PRLS license valid for? It is 2 years that PRLS licenses are issued for. Licensee means a person licensed to conduct a prepaid rental listing service or a person engaged in the business of a prepaid rental listing service under a real estate broker license. Question: are real estate licensees authorized to help others buy and sell mobile homes? The answer is yes, as long as the mobile home has been registered with the Department of Housing and Community Development. Next question. What is the recovery account? The recovery account is a special fund established to help compensate parties who have obtained a judgment against licensees that is uncollectible. There are limits to the recovery account. It is $50,000 per transaction or $250,000 per licensee. Moving on to real property. Remember, real property refers to a tangible piece of land, building, or structure that would be permanently attached to the land. It is a term used to describe a type of real estate or physical property that is immovable and includes the land and everything attached to it, such as buildings, fences, and trees. So you may see a question asked of these 4 choices: a house, land, mobile home, or fixtures, which is not considered real property? Well, mobile home would not be considered real property as it is not permanently attached to a foundation. All of the others would be considered real property: a house, land, and fixtures. Appurtenance is a term that refers to an item or feature that is considered part of a larger property but is not attached to the main structure, such as a detached garage or fence. An easement is a legal right to use another person's land for a specific purpose. It allows the holder of the easement to access, cross, or utilize the land for the benefit of their own property. Easements can be for activities such as access to a road or water source, or for utilities like electrical or sewer lines. The owner of the land where the easement is located retains ownership, but must allow the holder of the easement to use the property for the specified purpose. Stock in a mutual water company is referring to a nonprofit organization that supplies water to a specified area. Don't forget, appurtenance is anything that is legally used for the benefit of the land and is considered to be a part of the land, but it is not attached to the main structure, such as a detached garage or fence. Metes and bounds is a method of land surveying and property description that defines the boundaries of a piece of land by using natural features, man-made features, and distances and angles from a starting point to surrounding landmarks. This method is used to precisely define property lines and ownership, and it is commonly used in the United States and other countries. What you need to know is that metes and bounds is used to follow each boundary for a certain distance, quite often for an irregular parcel of land. Let's look at the United States Public Land Survey System, otherwise known as the PLSS, which is a method used to locate and describe real property in the United States. It uses a system of townships and ranges to describe the location of a property. A township is a 6 mile by 6 mile square area and is divided into 36 1 mile square sections. Each section is further divided into smaller tracts of land that are described using their distance and direction from the corners of the section. The system provides a standardized and organized method for describing and locating land, making it easier for surveyors, real estate professionals, and others to identify and describe properties. The PASS method is a process used in the United States Public Land Survey System, township and range, to describe the location of a particular piece of land. Here's what you need to know. When starting in the upper right-hand corner, the PASS method applies a grid system over a given area with lines running both east to west, that's the range, and north to south, that's the township. To locate a specific piece of land, you would begin in the upper right-hand corner and follow the range lines to the desired range. Then you would follow the township lines down to the desired township. By combining the range and township information, you can pinpoint the specific location of a piece of land within the larger grid system. A section is a unit of land in the PLSS, and it's used to measure and describe a parcel of land. It is approximately 1 square mile in size, 640 acres, and is divided into smaller units for further identification, such as quarters and halves. A section is identified by its number within a township and range and is used as a reference for property ownership, boundary disputes, and land surveying. Again, the section would be A basic unit of the system, a square piece of land 1 mile by 1 mile containing 640 acres. Moving on, what is accretion? Accretion is the gradual increase or addition of land along a shoreline caused by natural processes, such as sediment deposit. It refers to the natural growth or buildup of land due to the action of water or wind. In property law, accretion can affect the ownership and boundary lines of coastal properties. Avulsion, what is it? Avulsion is a sudden and rapid change in a river's channel, usually caused by a natural disaster, such as a flood, that leads to the creation of new land or loss of existing land along the river's banks. In legal terms, avulsion refers to a sudden and noticeable change in a watercourse that results in a permanent loss or gain of land. Deeds. Here's what you need to know. There are certain requirements for a deed to be valid, and they are as follows. You're going to need to know these requirements. The grantor must be competent. The deed must be in writing. It must designate a grantee. It must be signed by the grantor. Must have a granting clause, and it must have an adequate description of the property. Quick question. Of the following, which one of these would make for a valid deed? For it to be acknowledged, signed by the grantor, recorded, or signed by the grantee? The correct answer is signed by the grantor. Some of the most commonly used types of deeds are grant deed, warranty deed, trust deed, and quitclaim deed. Here's what you'll need to know as far as the basics for these deeds. A grant deed conveys after acquired title, and it contains implied warranties. A warranty deed provides the greatest level of protection to the grantee. A trust deed has one person, the trustor, that holds legal title to property for the benefit of another person, which is known as the beneficiary. The quitclaim deed is when the grantor quits or relinquishes any claim or interest that they may have in the property and transfers it to the grantee. Moving on to freehold estates. Freehold estate is a type of property ownership that gives the owner full and permanent ownership of the property with no limitations on the duration of the ownership, as long as they obey the law. The owner has the right to use, occupy, transfer, or dispose of the property as they see fit. There are 3 types of freehold estates that you will need to know. They are fee simple, which is the most common. Fee simple defeasible is more limitations. And life estate, which is in regard to estate planning. Going back to fee simple, the most common, which is referring to a type of property ownership that grants an individual or entity complete and unencumbered ownership of a piece of real property with no conditions, limitations, or restrictions on the transfer of ownership or the use of the property. It is the most complete form of ownership in real property law and is often referred to as a fee simple absolute. Fee simple divisible is the more conditional type of freehold estate, and it is a type of freehold estate in which the ownership of the property is subject to certain limitations or conditions and may be terminated if the conditions are not fulfilled. The property ownership reverts back to the grantor or to another party in the event of the breach of any conditions specified in the grant of the estate. As for the life estate type of freehold estate, and this means that the property is held for the duration of a lifetime. Upon the life tenant's death, the property reverts to another individual, otherwise known as the remainder man. The life tenant has the right to use and enjoy the property, but cannot sell, transfer, or encumber the property in any way that would affect the rights of the remainder man. There's also something known as a less than freehold estate, which is an estate held by one who rents or leases property. It is also referred to as leasehold or non-freehold, and that would be a less than freehold estate. Moving forward to the chain of title, this is the history of documents affecting title to a property. There's another term that you'll need to know, which is adverse possession. It's a legal concept, and it allows a person to gain ownership of a piece of real estate through possession and use, even if they do not have legal title to the property. Sometimes affiliated with the process of squatters' rights as a way to transfer property rights from one person to another without the use of a deed or formal documentation. Adverse possession must also show that they have a good faith belief that they own the property and that they have paid any taxes or other expenses related to the property. You may be asked, how long does it take to acquire title by adverse possession by paying for all property taxes? Correct answer is 5 years. Easements are legal rights that allow a person to use someone else's property for a specified purpose. The different types of easements are as follows. Easement in gross. Easement that benefits an individual or entity and is not attached to any specific piece of land is an easement in gross. Prescriptive easement refers to hostile interests of the owner. 5-year non-use termination. And then necessity easements, often created by the courts to prevent landlocked property, are another type. And it is an easement that is granted to an individual to allow them to access their property when access is otherwise blocked. An easement in gross, again, has right of way over an owner's land. An example of it would be a gas company that doesn't own adjacent land. Moving on to ownership in severalty, which is owned by one person and not jointly with any other person or entity. It is the opposite of joint ownership, in which 2 or more people own property together. Some possible ways to take title include sole ownership, trust, joint tenancy, tenancy in common, and community property. Sole ownership indicates that the property is owned by one person. Again, sole ownership indicates that the property is owned by one person. Joint tenancy is property owned by two or more people, and each person has equal right to use and possess the property. Upon the death of one joint tenant, the remaining joint tenants will automatically inherit the deceased joint tenant's interest in the property. There are 4 unities of joint tenancy, and they're in no particular order. The unity of interest means that each co-owner holds the same type and equal share of the property. Unity of title means that all co-owners have the same title to the property obtained through the same instrument. Unity of time means that all co-owners acquired their interest in the property at the same time. And unity of possession means that each co-owner has an equal right to possess the entire property. Again, the 4 unities of joint tenancy in no particular order is as follows: interest, title, time, and possession. Before we continue more on the different meanings for the ways to take title, let's talk a little bit more about joint tenancy. A special benefit of joint tenancy is the right of survivorship, which means that if one joint tenant dies, their interest in the property passes automatically to the surviving joint tenants, bypassing the deceased joint tenant's estate and avoiding the need for probate. This feature allows for a seamless transfer of property ownership and can be useful for estate planning purposes. Moving on to tenancy in common. This refers to property that is owned by 2 or more people, but each person has a separate and distinct ownership interest in the property. Upon the death of one tenant in common, the deceased tenant's interest in the property will pass to their heirs or beneficiaries rather than to the remaining tenants in common. Community property in California. Community property is owned equally by both spouses or domestic partners unless there is an agreement to the contrary. It is property acquired during a marriage or registered domestic partnership. Moving on to a trust, which is a legal arrangement in which one person, the trustee, holds legal title to the property for the benefit of another person, the beneficiary. There are many different types of trusts that can be used to hold title to real estate, including living trusts, revocable trusts, and irrevocable trusts. All right, now that we have defined all of the ways to take title that you will need to know about for California principles, we are going to define a quitclaim deed. A quitclaim deed is a legal document that transfers ownership of real estate from the grantor to the grantee, but does not guarantee that the grantor has any ownership interest in the property. This document is typically used to remove any potential title issues or conflicts, as well as to end any deed restrictions. A transfer of real estate ownership from a grantor to a grantee through a legal document where the grantor gives up any claim or interest in the property to the grantee is known as a quitclaim deed. Quitclaim deeds make no express or implied warranties that the grantor owns any interest in a property. It's usually used to clear clouds on title, and it could be used to terminate deed restrictions. Moving on to reconveyance deeds. This is used to transfer ownership of real estate back to the original owner or to another person. It reverses the transfer of ownership previously made through a conveyance deed. Put differently, it's just the return of title to a borrower after paying the debt by the trustee. Moving on to encumbrances. What is an encumbrance? An encumbrance is a legal claim or charge against a property that affects the ownership of the property. Some examples of encumbrances would be liens, easements, covenants, or other restrictions on the use or enjoyment of the property. Moving on to deeds of trust. A deed of trust is a legal document that is used to secure a loan taken out by a borrower, trustor, to purchase real property. It conveys the title to the property to a trustee who holds it as a security for the loan in the event of default on the loan. The trustee can initiate a foreclosure sale of the property to repay the loan. The trustor retains the right to use and occupy the property until the loan is paid in full. And the deed of trust it's a financing instrument, and it's most favored in California. And lastly, we have knowledge of our terms, that a borrower and a mortgager are two terms that are often used interchangeably in the context of real estate transactions. A borrower is a person or entity that borrows money from a lender in order to purchase or finance a property, and a mortgager is a person who pledges property as collateral in order to secure a loan. In both cases, the borrower or mortgagor is the party that's responsible for paying the loan to the lender. Since the two terms refer to the same person or entity, they are often used interchangeably. Thank you for joining us for the first part of our Realty School 101 Principles course review for California real estate. We hope you found this first section helpful and informative, and that you're feeling more confident and prepared for the final exam. We understand that learning can be challenging, but we are here to support you every step of the way. As we conclude this first part of the review, we want to encourage you to reach out to us with any questions or feedback you may have. Our 24/7 support line is available at 888-385-0087, and we're always here to help. We'll be back soon with the second part of our review, where we will continue to delve deeper into the real estate industry and help you prepare for the exam. In the meantime, we encourage you to continue studying and practicing what you've learned so far.